The criminal law and procedure question from July of 2004 probably is the most difficult criminal law and procedure question to appear on the California bar exam in the last 25 years. Now, maybe that's not your personal experience as you review a bunch of these questions, but take it from me. I think this is about as hard a question as the bar examiners can come up with on any topic. Not really because the issues presented are all that difficult, but because there are so many of them and because the factual context is so complicated. Take a look at the call of the question. It appears to be reasonably straightforward. Call number 1. May Dan properly be convicted of either first-degree or second-degree murder, and, if so, on what theory or theories for A, the death of Art, B, the death of Bert? Well, this is a pretty easy call of the question to organize. For each of these two victims, we'll have a separate discussion of first-degree and second-degree murder, and that ought to give us a reasonable platform to consider the facts and the law involved. 2. May Chuck properly be convicted of any crimes, and, if so, what crime or crimes? Discuss. It turns out this is a very difficult question. Again, not because the issues presented are all that difficult, but because you've got time pressures. And you have to think of as many different crimes as possible. They aren't given to you, as many questions give you the charges. And then finally, call number 3. How should the court rule on Dan's motion to dismiss? Discuss. Well, obviously, we can't organize an answer to this call of the question without reading the fact pattern, because we've got no idea what the basis is for that motion. And as it turns out, this question also ends up being fairly difficult, again, not because it's hard, but because it's not commonly tested and the facts are fairly complicated. The basis of Dan's motion to dismiss is a violation of his speedy trial rights, which arise from the Sixth Amendment. And as it turns out, this is a motion to dismiss that probably ought to be granted. Now let's have a look together at the fact pattern. And you'll see it's pretty complicated. In paragraph 1, we meet Dan. That's our first defendant. And then we also meet Art and Bert. These are the two victims that were asked about in call of the question number 1. So here's the first fact in the question, and it makes the problem more complicated than usual. Ordinarily, we've got victims who are genuine victims. Here we've got two bad guys who end up being victims. And in paragraph 1, we learn how the first bad guy, Art, meets his demise. He's killed by the robbery victim, Vince, V for victim. And what happens is Vince, this victim, gets to be a killer rather than a victim. He doesn't die in the question. This time, it's one of the robbers who dies, Art. So Dan and Bert, who ends up being our second victim, get into Bert's car and they leave the scene. In paragraph 2, we meet our second defendant. That's Chuck. And Chuck is the person whose house Dan and Bert arrive at after the robbery. And they decide to split up the money there. Chuck threatens to go to the police if they don't give him a cut of the money. And so he gets $150 from Bert for his trouble. Then Dan asks Bert for half of the remaining $600. And Bert claims that he should get $500 because his car had been used in the robbery. As a result, Dan shoots and kills Bert and takes all of the remaining money for himself. Dan removes the money from Bert's pocket. Okay, well, this is a paragraph thick with facts. And now we have to consider the possible liability of Chuck, because we don't get any more facts about the crime after paragraph 2. So as we consider Chuck's situation, we're going to have to consider, obviously, accessory after the fact to both the robbery of Vince and to murder, but he's also going to have to face potential criminal charges for extortion and for receiving stolen property. Now, I can tell you for sure that the receiving stolen property issue is not a life or death issue for a candidate taking this bar examination. However, it is an issue, and the issues surrounding Chuck are complicated enough that I think this is an unusually challenging question. Now take a look at paragraph 3, the longest paragraph in the fact pattern. All of these facts have dates in them. a situation we're a lot more familiar with in contracts or wills and trusts or community property. But here we've got a series of dates that deal with the prosecution's failure to bring Dan to trial in a timely manner. And we've got some pretty frivolous reasons for a people's continuance listed here. Finally, Dan moves to dismiss. So we take a step back after we see the call of the question again, and we realize we've got an enormous number of fairly complicated issues to resolve. Now, intellectually, these issues are not all that hard. What's hard about this question is organizing a thorough answer and then writing that answer under timed conditions. I think you'll see this is one of the longest, if not the longest model answer that I've written. And I personally experienced this as a wild racehorse. So now turn the page and have a look at the outline of issues that I've presented. And you'll see that here I'm not doing anything especially innovative. I'm just following my own approach scrupulously. The first of the three calls of the question has the most detail to it. We've got to talk about Dan's liability for murder, and you'll see that I have those separate sections for Art and for Bert, and I talk about first and second degree murder in each case, although they only get separate categories in our discussion of the analysis of the death of Art. Also, with regard to each of these victims, I consider defenses that would be offered by Dan. Ultimately, despite my alleged or confessed defense bias, I convict this defendant of first-degree murder of Art and second-degree murder, at least, of Bert, and perhaps first-degree murder there as well. Now turning to Chuck, as I indicated before, what makes Chuck's situation so complicated for us is they don't give us the charges. We've got to think them up ourselves. And the easy one to show is accessory after the fact. But notice that I have a separate little section each for robbery and murder. Then I move on to consider extortion and receiving stolen property. And as we get to a brief consideration of my answer, you'll see that really none of these sections is terribly long, but they add up. All of them are reasonably in depth. And so again, organization becomes a key to give us a prayer to do this kind of work within time constraints. Then finally, I turn to Dan's motion to dismiss. It seems to me that although this was the longest paragraph in the fact pattern, this is some of the easiest material to organize. I just organize it chronologically, and I reach the conclusion that the motion to dismiss should be granted. So, we've reviewed the fact pattern, and we've reviewed the most appropriate way to outline an answer to this question. Now, there are other appropriate ways to organize, like, for example, writing this answer in 4 or 5 big fat paragraphs with no headings. It's possible to write a passing answer to this question pretty much in that format. But I suggest that it is much more likely that you will do your best by organizing carefully and then writing analysis that is as focused as possible. So, very briefly, let's have a quick look at my comparatively long model answer. And with regard to Dan's liability for murder, you'll see I spend 2 complete pages and a little more on this section. Now, I think it would be possible to leave out some of these details here. In particular, some of the law. This answer is a little bit more dense with law than many of my answers in this seminar, to the extent you haven't already noticed. But as you'll see up front, the very first couple of sentences indicate the procedural status of the case. I lead with the facts about the death of Art and Bert, and then I indicate Dan's legal situation. I also lead with the conclusion, although that's certainly not necessary. I focus on the death of Art, and notice again that I lead with the facts, in particular that this victim was shot by the proprietor of the convenience store that Art, Bert, and Dan had just robbed at gunpoint. Then I focus on first-degree murder, and in particular the felony murder rule. Notice carefully, as you look at the first 2 paragraphs, I talk about first-degree murder separately from felony murder, and then I get into details about felony murder in the second paragraph. As you get to the conclusion within this section, I think you'll find that it's quite apparent that Dan is going to be convicted of felony first-degree murder for the death of Art. but I still consider second-degree murder, which I'm able to toss off in a couple of short sentences. And then I focus on the defense, which is that Dan didn't shoot this victim. And in fact, in some jurisdictions, felony murder isn't allowed under these circumstances. But it seems to me the most likely conclusion is that Dan is going to be convicted properly of first-degree murder for the death of Art. Then I turn to the death of Bert. Now, this is a somewhat more simple situation, at least superficially, because Dan shoots this victim directly. It seems to me that we've got a fairly evident case of second-degree common law murder just based on these simple facts. But a more in-depth analysis shows that there are felony murder possibilities both with regard to the robbery of the store and with regard to the robbery of Bert. Now, here we're able to distinguish the facts from one another. Felony murder really won't be applicable with regard to the robbery of the store because that crime was complete before the shooting of Bert. Now, with regard to the robbery of Bert, that's a different situation. In this case, the problem is that Dan didn't decide to steal this money until after he killed this victim, not before. So I suggest that felony murder really isn't going to be appropriate for this defendant under these facts. The plain facts of these cases are the prosecution's best bet. The defendant has a defense, a lame defense of provocation, but ultimately I conclude it's a bad defense. And I suggest that the ultimate result is that there will be a first-degree felony murder conviction for the death of Art, second-degree murder for the killing of Bert. Then I turn to Chuck's criminal liability. And here it seems to me that the analysis actually is quite simple. I spend a fair amount of time explaining what an accessory is, particularly an accessory after the fact, and then I get into all of the factual details that are relevant to establishing an extortion charge, and then robbery and murder. I have a separate section on extortion and receiving stolen property, and it seems to me that Chuck properly is going to be convicted of being an accessory after the fact to the robbery of the store, and also extortion and receiving stolen property. Finally, the last section of the question, of the answer, is about question 3, the motion to dismiss. Now, this is a very unconventional issue, and a speedy trial motion is, well, really they're not uncommon on the multi-state, but here on the essays, they are very rarely tested. And I think you'll see as you look at the facts here, one of the reasons why it isn't tested very often is because it's so simple. All you've got to do is look at the dates, look at the justification given for the delay, and ask yourself a couple of questions. Is the delay too long? And if the delay is too long, is this delay excused by some logical explanation with regard to the facts? And you see that I'm using the facts as headings here. The defendant requested a trial on October 15th, 2002, and finally the court has continued the case to September 1, 2003, over some very flimsy justifications offered by the people. So, even though this defendant clearly is a bad guy who's guilty with a capital G of some extremely serious charges, the fact that the government is unable to bring him to trial in a timely fashion ought to prevent the government from bringing this defendant to trial at all. And that wraps up a consideration of a question that I think you'll agree is unusually brutal. It's brutal because it requires you to think on your feet and do a remarkable amount of hard work under strict time conditions.